Welcome to new episode of Bhjarateeya Nyaya Sanhita 2023. Today we continue with the discussion of definitions such as offence, then omission, person, public, etc. Section 2, subsection 24 of the Bhjarateeya Nyaya Sanhita. Offence. Except in the chapter and sections mentioned in subclause A and B, the word offence means a thing made punishable by this Sanhita, but in chapter 3 and in the following sections, the word offence means thing punishable under this Sanhita or under any special law or local law. The corresponding provision is section 40 of the Indian Penal Code. Offence. Except in the chapters and sections mentioned in clause 2 and 3 of this section, the word offence denotes a thing made punishable by this code. What is meant by offence? In law, an act considered to be an offence when it is punishable with law. In other words, an act should be defined as an offence, the violation of which shall be punishable in accordance with the law, then only it will become an offence. So anything that is illegal or immoral or unsatisfactory in common parlance may not be an offence in the statute. For example, if a person wants to marry, he has to marry according to the law concerning the marriage, either the Hindu Marriage Act or a Christian Marriage Act or some other personal law, or even a special marriage act can be applied. Assume for a moment that person is not marrying at all. It's not an offence. So a thing permitted under law, if he is not doing, that is not an offence. And if he is marrying in accordance with law, then also it is not an offence. But if an act is defined to be an offence, the violation of which is punishable under a statute, then it becomes an offence. For example, killing of a human being by another human being, by violating the law, it becomes an offence. If a doctor during surgery accidentally causes death of a human being, it is not an offence. But a person with the same knife or a similar knife with an intention to kill a person causes the death of another human being, that becomes the offence of murder. So any act which is defined as an offence, the violation of which is made punishable, then only it becomes an offence. Otherwise, though in the common parlance an act may not be satisfactory or may be considered to be not good to the human behavior, or it may not be moral in the eye of human beings. For example, two persons marrying without marriage living together, it may not be an offence. But in the common parlance, it may be not a good thing. It may be considered to be immoral. So, unless an act be defined as an offence, it cannot be treated as an offence. The violation of which must result in punishment, that is also must be declared by the law. Then comes section 2, subsection 25, omission. Omission denotes as well as a series of omission as a single omission. The corresponding provision in the Indian Penal Code is section 33. Act and omission. The word act denotes as well as series of acts as a single act. The word omission denotes as well as a series of omission as a single omission. The word omission is quite contrary to the word offence or act. In an act which is considered to be an offence, something positive, something active will be done by a person. For example, killing of a human being by another human being. In omission, the situation is just contrary or just the reverse. In this, a person is not doing anything. He just omit to do what he is supposed to do. For example, a mother of a child of tender years, that mother is supposed to take care of the child. A guardian is supposed to take care of his ward. The parents of a minor, they are natural guardians, so they have to take care of that minor. A police officer who has to take care of the entire duties in that police station. A bank manager who has to take care of the currency or cash or other valuables in the bank. Suppose if they are not doing their duty, then it amounts to omission. So omission is just contrary to the act. Act is something active, whereas omission is something passive. So a student of law or a legal practitioner must keep in mind the difference between the act and omission. Section 2, subsection 26 of the Bhjarateeya Nyaya Sanhita. Person. Person includes any company or association or body of persons, whether incorporated or not. The corresponding provision is section 11 of the Indian Penal Code. Person. The word person includes any company or association or body of persons, whether incorporated or not. The term person is very important in law. Normally, we mean person means individuals. But in the act, or in the law, or in the Sanhita, or in the code, the word person includes a company, association of persons, whether incorporated or not. So a company is considered to be a person in the eye of law. A person, an individual, is also considered to be a person in the eye of law. A group of persons, more than one, while doing something in common, they are also considered to be person or persons. The thing is, the incorporated or not, or means whether they are registered as a company under the relevant law of the land or the Companies Act or the partnership firm or partnership act is irrelevant. Group of persons, whether incorporated or not, still they are considered to be persons. So the definition is an inclusive one, which means many other things can be incorporated into that particular definition. So person means individual, group of persons, company, or body corporate, or even association of persons, whether incorporated or not. Company must be registered as a company under the Companies Act by the Registrar of Companies. A partnership firm must be registered as a firm by the Registrar of Partnership Firm. But in the Indian Penal Code, as well as in the Bhjarateeya Nyaya Sanhita, whether they are incorporated or not, whether they are registered or not, still considered to be a person. A group of persons, for example, it is done by some assailants, a gunda gang, they attack a person, they just trespass into a property, or they make a house breaking and killing someone. All of them are considered to be persons. If a company commits an offense, this company cannot be put behind the bars, but the persons behind the company can be put behind the bar. That technical term is known as lifting a corporate veil and finding out the persons who are guilty and they are prosecuted. So the word person is of wide meaning in this statute. Public servant, section 2, subsection 28 of the Bhjarateeya Nyaya Sanhita, means a person falling under any of the descriptions, namely every commissioned officer in the Army, Navy or Air Force, be every judge, including any person empowered by law to discharge, whether by himself or as a member of any body of persons, any adjudicatory functions, every officer of a court, including a liquidator, receiver or commissioner, whose duty it is as such officer to investigate or report on any matter of law or fact, or to make, authenticate, or keep any document, or to take charge or dispose of any property, or to execute any judicial process, or to administer any oath, or to interpret, or to preserve order in the court, or and every person specifically authorized by a court to perform any such duties. Every assessor or member of a panchayat assisting a court or public servant. Every arbitrator or other person to whom any cause or matter has been referred for decision or report by any court or by any other competent public authority. Every person who holds any office by virtue of which he is empowered to place or keep any person in confinement. Every officer of government whose duty it is as such officer to prevent offences, to give information of offences, to bring offenders to justice, or to protect the public health, safety, or convenience. Every officer whose duty it is as such officer to take, receive, keep, or expand any property on behalf of the government, or to make any survey, assessment, or contract on behalf of the government, or to execute any revenue process, or to investigate, or to report, or any matter affecting the pecuniary interest of the government, or to make, authenticate, or keep any document relating to the pecuniary interest of the government, or to prevent the infraction of any law for the protection of the pecuniary interest of the government. Every officer whose duty it is as such officer to take, receive, keep, or expand any property, to make any survey or assessment, or to levy any rate of or tax for any secular common purpose of any village, town, or district, or to make, authenticate, or keep any document for the ascertaining of the rights of the people of any village, town, or district. Every person who holds any office by virtue of which he is empowered to prepare, publish, maintain, or revise any electoral roll, or to conduct an election or part of an election. Every person in the service or pay of the government, remunerated by fees or commission for the performance of any public duty by the government, in the service of pay of a local authority as defined in clause 31 of the section 3 of the General Clauses Act 1897, a corporation established by or under the central or state act, or a government company as defined in clause 45 of section 2 of the Companies Act 2013. Explanation. Persons falling under any of the descriptions made in this clause are public servants whether appointed by the government or not. Every person who is in actual possession of the situation of a public servant, whatever legal defect there may be in his right to hold that situation, is a public servant. The corresponding provision is section 21 of the Indian Penal Code. A wide definition is given for the term public servant. It includes from the top to the bottom, right from the top persons of the army, navy, air force, or even a police officer, or a jailer, or employees of the government in the revenue department or survey, or anyone paid by the government, or anyone who is in actual possession or position of a public servant is considered to be a public servant. The term public servant is very important in law. A public servant has got legal authority to act as a public servant in discharge of his duties, in discharge of the sovereign functions of the state. And suppose if a person assists a public servant under the instructions of a public servant, then he is also protected as a public servant. The main protection available for a public servant is acting in good faith. A public servant acting in good faith cannot be termed as an offense. For example, if a person violates the law, he cannot be controlled by anyone. He takes the law into his hands. He attacks someone. He becomes an assailant. A police officer who is considered to be a public servant can arrest that person. Police officer can use necessary force to control that person. Police officer can take that person into custody. Then police officer can prosecute also. Assume for a moment, a police officer came to a particular locality and someone is violating the law. He is being deprived of self-control and he becomes dangerous to the general public. And assume for a moment that person is so powerful or mighty that the police officer cannot control that person. Under those situations, the public servant or police officer can ask anyone present in the public to assist him. So that common man, member of general public, also become a public servant while assisting the public servant under the instructions of the public servant. And they can arrest that person also. So the public servant is given predominance in the eye of law. They are part of the state or the government. They will be discharging their duties. And if anyone prevent the public servant from discharge of his duties, it will become an offence under section 353 of the Indian Penal Code. Interrupting a public servant in discharge of his duties. So public servant is a person protected under the eye of law. He can discharge his duties, and if anyone interrupts the duties or discharge of duties by a public servant, that itself becomes an offence. Whereas the public servant, in good faith doing something, though it may cause some harm to a person, he is protected under law. But one thing is to be noted: the very same public servant, by misusing his authority with bad intentions, with malafide attacks someone or rob someone's property or misuse the property or even forcibly take the possession of the property or money, then he can be prosecuted. So while discharging his duty, this person will be protected in good faith, but if he is in bad faith, then he can be prosecuted. So that decision will be taken by the government under the section 197 of the Criminal Procedure Code. So that protection, though available to the public servant, it is not absolute. The government will be taking the final decision. This discussion will be continued in the next episode. You are requested to convey your suggestions and you may ask your doubts. It will be clarified in the next episode. Thank you.